Good morning, everybody. I'm very happy to introduce this STALS seminar. My name is Giacomo Delledonne. I am an assistant professor of constitutional law at the Scuola Superiore Sant'Anna in Pisa. Together with Giuseppe Martinico and Filippo Fontanelli, I'm one of the editors of the Sant'Anna Legal Studies, STALS, a project and a paper archive. Today, our webinar has a very topical issue, regulating cumulative environmental change in multi-layered legal contexts. And let me just introduce today's speaker. Rebecca Nelson is an associate professor at Melbourne Law School, Australia. Her research focuses on environmental and natural resources law and policy. And in this respect, her research puts special emphasis on empirical research and practical solutions. She held an ARC Discovery Early Career Researcher Award, and before that, she defended a doctoral dissertation at Stanford University. We are very happy to host this seminar this morning, which is part of the long-standing fruitful cooperation between STALS on the one hand and Eurac Research on the other hand. And I would also like to thank Giuseppe Martinico and Federica Cittadino for their help in making this event possible. Now, Professor Nelson, the floor is yours. Thank you for being here this morning.
Very much. Grazie tanto a Giacomo e pure a Giuseppe per l'invito e per le parole gentili. È veramente un onore essere ospitata dal STALS Pisa e sono contentissima di unirmi con dottoressa Cittadino per discutere l'argomento regolamentare il cambiamento ambientale cumulativo nel contesto del governance multilivello. E mi dispiace solo di non poter essere lì di persona. E adesso conosco i miei limiti e procederò in inglese. So today I'd like to introduce a work in progress to be published by Cambridge University Press next year, hopefully, entitled Cumulative Environmental Effects and the Law, Developing Theory, Evaluating Global Empirical Evidence, and Designing Best Practice. The aim of the work is to offer a framework for analysing, from a legal perspective, problems of cumulative environmental change, and then to apply that framework to a series of case studies around the world. So today I'll be discussing a case study which is still in progress, unfolding, relating to groundwater and environmental justice in California. And in relation to this case study, I want to gratefully acknowledge the work of my collaborator, Deborah Perrone, who is Assistant Professor in Environmental Studies at the University of California, Santa Barbara. So I'm really looking forward to the discussion today, which I think will give me some really valuable food for thought as I write the book. To explain this first slide, I've used the image of a frog and a pot of boiling water because this is the metaphor that's often used to explain incremental cumulative change. The frog in the pot of water is slowly warming, but doesn't realize it because of the gradual cumulative nature of the threat. And so this talk is really about structuring and coordinating laws to protect this metaphorical frog. So in overview, I will set the scene by explaining what I mean by cumulative environmental effects. I'll sketch out the kinds of law that are relevant to dealing with these effects, and I'll present a framework for helping to untangle and understand how complex multi-layered laws deal with cumulative effects. And I'll explain why multi-layered legal contexts make this quite difficult. And then I'll move on to the case study illustration of groundwater in California. So first, to explain what I mean by cumulative environmental problems and the implications of a multi-layered legal context. I think if we consider the nature of contemporary environmental problems, a lot of them have really important challenges in common. So we're largely not talking about single actor, single event catastrophes that make the front page of the paper, like a nuclear meltdown or an oil spill. These are problems that are cumulative in that they have many and sometimes innumerable contributors. And so climate change is an obvious example, other forms of air pollution. Even the expansion of paved areas in cities, which increases risks of flooding. The contributors might not all be large, they might individually be quite minor, but they can accumulate to become collectively significant. The problems are also complex in that the way that the individual effects caused by those contributors interact and aggregate have high requirements for scientific information and other forms of information. And that's notoriously true for problems like climate change or understanding the decline of coral reef systems. And the problems are also insidious. They build up slowly and inconspicuously, like, say, increasingly endangered species. So I think at a very basic level then, the law needs to be responsive to these characteristics. It needs to comprehensively cover many activities, even if they seem small. It needs to facilitate the production and the use of information and to trigger action even if the problem isn't immediately obvious. So if we ask, well, what kinds of laws are we talking about that are implicated in dealing with cumulative environmental problems? The answer is lots. For reasons of brevity, though, I'll describe the ones that arise most obviously. So first of all, the world's most common type of environmental law is environmental impact assessment, which provides for assessing the environmental impacts of an individual activity, often with a mandate to consider the cumulative effects of the proposed project in the context of other projects, but nonetheless, the focus is on one individual project. Strategic environmental assessment tries to assess the effects of a whole series of projects or a policy at a higher spatial scale. And scientists often say that this is the best way to consider cumulative effects. But I think, in fact, much broader laws are directed to cumulative environmental problems, even if they don't use those terms or that language. So that includes natural resources laws, which can either control individual activities, like requiring a permit for a factory to discharge pollution, or laws that limit aggregate environmental effects by imposing larger scale limits, say a limit on the total pollution concentrations in a river. So any of these broad kinds of legal approaches, in fact, all of them are often found at multiple levels of government, from local to provincial to regional to national and even international laws. And as we'll see in the case study, there's also scope to consider laws that are perhaps even broader than the kinds that I've listed here. So in many jurisdictions, multiple vertical levels of government have regulatory competency in relation to the environment and natural resources. Now, I don't offer a normative view of which level ought to have this competency. My analysis proceeds from three positivist observations, being that multi-layered legal contexts for dealing with cumulative environmental problems are just inevitable and inescapable. This can be for a couple of reasons. So sometimes multiple levels of government have shared competency over the same subject matter. Other times, different levels of government regulate different subject matters. So in a legal sense, it's not concurrent, but the subject matters are physically connected so that the regulations interact to produce an ultimate environmental outcome. Understanding a cumulative environmental problem requires understanding all of these layers. Multi-layered laws are also dynamic, for example, as the powers of one level of government expands or shrinks with different constitutional interpretation. And that means that appropriate legal responses to cumulative environmental problems will probably not be set and forget. They will require ongoing scrutiny and adaptation. And then finally, multi-layered laws in the environmental space can be controversial as different levels of government jostle for influence and control. That feeds into the dynamism of these systems, and it can also make implementation difficult, which is why it's important to consider empirically what are the challenges that arise in implementing laws, not assuming that the law as written on paper is likely to translate into practice in a straightforward way. So a key question is then, well, how can we improve multi-layered laws for dealing with cumulative environmental problems? And how can we understand how they all interact in the first place? I'd like to put forward a four-part framework for analysing what relevant laws are doing to help diagnose where the potential legal problems might be. So the framework that I'm putting forward methodologically is the product of reviewing a lot of interdisciplinary literature in fields like environmental science, social psychology, cognitive science, and public policy to understand why is it difficult in general for society to deal with cumulative environmental problems, so that we can then ask, well, in what of those problems can law assist? And that literature review process yielded really four main functions that I think the law can carry out to help. As well as connecting with that interdisciplinary literature, as a comparative lawyer, my intention by this focus on legal functions is to provide a structure for comparison between different jurisdictional approaches. So the first function of law is in conceptualizing the problem. What is the valued environment? What are the effects that might harm it? And who does the law recognize or not recognize as contributors to the problem? A second function is gathering and sharing information to predict or detect cumulative effects. Good information is really important in the case of cumulative effects because incremental change is hard to detect even for experts. So the frog in the pot doesn't realize that the water is warming because it happens only slowly. Now the frog would be well served by a thermometer, which the law can provide for decision makers. A third function is intervening in response to unacceptable levels of cumulative effects, either to prevent or to remedy those effects. So laws that provide for intervention can take lots of forms, establishing a licensing regime, for example, or a right that can be defended against cumulative effects. The fourth role is coordinating action between agencies and governments and providing for public participation in relation to the other three roles. If we can consider the challenges of multi-layered legal systems against this framework, it exposes why it's so necessary for coordination to span each of those three other roles. So in relation to conceptualization, we can often see that different laws at different levels of government can take different approaches to what the environment means, including whether or not humans are conceived as part of the environment and when impacts become significant. They might only each deal with a small part of the problem, very much like a zoomed in photo, when dealing with cumulative environmental change requires us to take the panoramic view of the situation. A challenge related to information is that sharing information can be politically difficult, and it can also be technically difficult if agencies at different levels of government have different ways of collecting information. So it can be like comparing apples and oranges, and it can be quite difficult to aggregate that information to get a complete picture. The amount of resources that government agencies have to collect and analyze information can also be very different, with higher levels of government typically having more resources to devote to information gathering and analysis. And then in relation to intervention, for diverse constitutional or political or historical reasons, laws at different levels may apply to different sets of entities. So we can have a situation where in trying to catch different activities that may cause harm, different laws are like nets that have holes in different places that let different entities through those holes. Whereas dealing with a cumulative environmental problem requires a net that has no holes. So coordination is required to analyze changes that might need to be made to achieve that. So in summary then, we can consider that an individual level of government may have a legal response to an environmental problem that is blinkered. It can be constrained in how it understands the problem, collects information about the problem, and takes action in response to it. But coordination and participation can mean harnessing together all of those different blinkered views to make the legal response to a cumulative environmental problem much more powerful. So that's all quite conceptual. I'll now turn to a case study, which is still unfolding, as you'll see, but that I think illustrates this conceptual framework in a way that I think already reveals some interesting things. So water issues in California may seem far away, but I think they have larger relevance. First of all, this case study illustrates the complexity of dealing with cumulative environmental problems in a multi-layered legal setting. Second, it's an example of a problem that's actually very prominent globally. So at the international level, the human right to water has now been recognised for more than a decade, but actually realising that right to water in practice fundamentally depends on controlling cumulative environmental impacts on the sustainability of the resource, both pollution impacts and depletion impacts. But as we see in the sign on the right of this slide, public debates about the right to water tend to focus on clean water and not so much on problems of depletion, which will be my focus here. Despite the lack of attention, clearly where we're talking about groundwater as a drinking water supply, dry wells that yield no water cannot sustain any sort of right to water and can cause very serious problems for communities and households that rely on them. So as the diagram on the left here shows, pumping groundwater at high rates can cause water tables to lower, which can cause shallower wells, which are typically domestic wells for people's households, to go dry. If you have resources, you may be able to pay the costs of deepening your well. If you don't have resources, you may not be able to do that. So this is a potential environmental justice problem that is now occurring around the world. Fresno is sort of the perfect storm of issues at the intersection of groundwater sustainability and environmental justice, except that there is no storm because the whole region is in a mega drought, which is the driest period since 800 AD. So in California, many people who think of the Central Valley where Fresno is located, so the Central Valley is the area, the valley that you see in the middle of California on the topographic map with the Fresno Aquifer highlighted. Most people who think of that area would think of beautiful, lush almond groves. So this county produces the most agricultural commodities by value in the entire United States, and agriculture uses a very large amount of groundwater to do this. So Fresno is the largest city in the Central Valley. It's also the poorest major city in California. In terms of depletion, it is the most overdrafted basin in the state of California, and it suffers from severe pollution concerns, mostly because of nitrate pollution from fertilizers that are applied to farms. This is a particular problem because the area is very reliant on groundwater. So for drinking water, for city water services, for wells that serve non-urban disadvantaged communities, and for individual rural households. California has had a very long advocacy and legal and policy history in relation to environmental justice. The concern that racial minorities and low-income groups bear a higher burden of environmental risk than other groups. So it was the first state, for example, to legislate in relation to environmental justice, which mandated its Environment Protection Agency to consider environmental justice in its activities. The problem of groundwater depletion, though, has not traditionally been seen as an environmental justice issue. But in fact, it is, I argue, because the physical nature of the groundwater system exacerbates disadvantage. If you have a domestic well, it will likely be shallow, it will be vulnerable to drying out and being polluted, whereas deeper, higher capacity agricultural wells are much less vulnerable and withdraw enormous amounts of groundwater, cumulatively causing impacts to other users. Probably one of the most compelling reasons to look at Fresno is for its incredibly complex setup in terms of multi-level governance. involving legislation and statutory plans made by local governments, as well as multiple state agencies under lots of different state legislation, and also federal agencies under federal legislation. I think the problem can be most poignantly summarized by a quote from a resident of Fresno County who relies on a household well and who blames farms when she says that sometimes we have brown water and sometimes we have no water. So we can think of the process of understanding the laws involved in this problem as a process of casting a statutory net, catching statutes at any level that affect cumulative environmental problem of groundwater sustainability in Fresno, in terms of discharges of pollution or withdrawals of groundwater that accumulate to cause depletion that can affect vulnerable communities. As we pull up that net, in the case of Fresno, we end up with a large number of laws in 5 quite distinct categories. For present purposes, the precise laws are less important, although I will show you what they look like. They're less important than the general observation that there's an enormous amount of fragmentation. So each of these 5 areas of law deals with just a part of the problem, not the whole problem. And it tends to interact in a way with the other laws that would not overcome the challenges of this fragmentation. Each of these areas of law have statutes made by multiple levels of government, a combination of federal, state, county, and city. Applying the 4-part conceptual framework to this can help untangle where the gaps are and difficulties with the ability of these laws to address groundwater sustainability as an environmental justice concern. So, turning first to intervention. These laws use lots of different approaches to intervention in response to cumulative effects. And I start first with intervention because I think that's what lawyers will most think about first. You know, what does this law do? So some environmental laws and water pollution laws assess and approve individual activities in a way that considers impacts on the resource as a whole, along with other impacting activities. Water pollution laws also impose quantitative standards for overall acceptable water quality conditions, which flows through to permits. By contrast, safe drinking water laws apply standards for acceptable end-use conditions and require that state agencies consider a human right to water, although this is just a consideration and it's not an enforceable mandate to supply water. We also see some statutes adopting requirements to produce information about individual activities in their cumulative context or to monitor resources conditions, but they don't actually require action to change those conditions. So some groundwater information laws and environmental laws fall into that category. Interestingly, for a cumulative effects analysis, there are also multiple different statutory planning processes. Long-standing basin planning processes for water quality and general plans for land use planning. Most recently, as of legislation from 2014, groundwater sustainability plans that have to be formulated by local agencies. And I'll talk more about those in the rest of the presentation. We can see here that it's not from a lack of law that these problems exist. There's plenty of law and plenty of modes of intervening. But a very notable gap in the laws that this process nets is law that regulates how much water a person can take out of their wells, which is a crucial form of intervention to prevent groundwater depletion. In California, this issue has been left up to local agencies, which often represent agricultural stakeholders rather than being a responsibility of the state. And these local agencies have not introduced regulations to limit groundwater withdrawals, which is an important hole in the intervention net. Turning to conceptualization, and this is the clearest one here, there are obvious differences in how these laws conceive of this problem in space. So under the Federal Safe Drinking Water Act in 1979, the United States EPA designated the Fresno sole source aquifer, which I've outlined there in a thick black line, as the sole or principal source of drinking water for the area. And that was based on scientific information produced by a federal scientific agency. The outer boundaries that you see show a groundwater designation given by the state of California for its recent 2014 legislation, the Sustainable Groundwater Management Act, which I'll call SGMA. So those boundaries are the product of both input from a state scientific agency and an extremely intensive, hostile and contested process to draw these boundaries with local participation and input. The internal boundaries, so that the coloured blocks that you see, are the jurisdictions of the local agencies that are charged with formulating groundwater sustainability plans to address groundwater sustainability overall under state oversight. So clearly this is a pretty busy multi-level jurisdictional space overlying a single physically connected system, meaning that these agencies need to coordinate their actions to ensure that they won't unknowingly undercut each other's actions. Across different laws and different levels of government, we also see different ways of conceiving of the physical aspects of the problem of groundwater sustainability. So some laws deal only with water quality and they ignore water quantity. Local laws deal only with the drilling of wells, but not directly with the water withdrawn from the well. The 2014 SGMA legislation that I mentioned does deal with both quantity and quality, and it asks local agencies to set goals for both of these things, but it's yet to be fully implemented. Nonetheless, reaching across that conceptual divide, encompassing quality and quantity, is important because in practice in the Central Valley, if groundwater is overpumped, which it is, levels decrease and the water that's withdrawn for drinking water becomes more and more contaminated. There are also other ways in which different laws at different levels conceptualize the problem differently. So safe drinking water laws only deal with the end product, the stuff that comes out of the tap, and not with the sustainability of the resource that's used to supply the water coming from the tap. Environmental laws deal only with individual proposed activities, and they have limited ability to influence the sustainability of the whole resource. So this legal fragmentation doesn't exist because no one realizes that all the aspects of the problem are important, but multi-level legal arrangements have been a challenge. As demonstrated by this quote, 44 years old quote now from the federal declaration that initially declared that this area was important as a sole source aquifer. It strongly recommended that a comprehensive quantity and quality groundwater management program be developed, but there was and is no federal jurisdiction to do this. And it has taken 40 years to get a state law passed that at least recognises connections between water quantity and water quality, and ultimately devolves responsibility for these issues to local agencies. A final, quite fundamental way that we see conceptual differences across legal layers is in relation to the human aspects of the problem, the populations of concern. So California's Human Right to Water Act imposes an obligation on state agencies to consider the right, which is said to apply universally to every human being, and it's expressed to apply to both water quality and accessibility. But it's unclear whether the term accessibility applies to problems like domestic wells going dry because of agricultural overpumping, as distinct from accessibility of a piped municipal water service in cities, for example. Environmental justice as a legal term is defined in Californian law as the fair treatment of people of all races, cultures, and incomes with respect to the development, adoption, implementation, and enforcement of environmental laws. And it really hasn't been adopted in relation to laws that deal with groundwater depletion issues because they're not seen to be environmental laws. So the groundwater related laws tend to make use of the much narrower concept of disadvantaged communities, and that's defined solely by income. And it doesn't capture the cumulative effects of diverse environmental burdens and socioeconomic vulnerability, which is the whole purpose of the concept of environmental justice. So laws in different areas that all deal in some way with groundwater sustainability use quite different ideas of the human aspects of the problem, as this diagram roughly approximates, But none of these concepts very clearly include groundwater depletion as an important issue for vulnerable human populations. This isn't just theoretical, it matters in practice. These maps show the way that these different concepts result in different communities of concern on which the relevant laws focus. So if you consider only income as the justice indicator, the areas in purple on the left-hand side emerge as communities of concern. If you consider the state tool for environmental justice concerns, you get a spectrum of concern shown as the darker shaded areas on the map on the right. And these maps are different. So in the case of the circled area here, one community that is not considered disadvantaged based on income alone turns out to be among the worst in the state if you consider pollution burden and broader indicators of population vulnerability. On the other hand, the reverse is true in other areas, as shown by the upper circle on the maps. The implications of these differences in how the human aspects of the laws are conceived is that the law may not intervene to address problems for groups of people that are not conceived to be in the focus of the law. So as examples, different groups of people may be eligible for government assistance to cope with water shortage problems or be the focus of efforts to ensure public participation in the administration of laws, or they may not, depending on how the relevant law conceptualizes the populations of concern. And to reiterate, neither of these two measures, disadvantaged communities or environmental justice, as it's currently understood, are conceived in a way that considers how groundwater depletion might affect these communities. That gap can be somewhat explained if we consider how relevant laws provide for information about groundwater problems. So what's the barrier to incorporating water quantity concerns into ideas of environmental justice in these laws? I think the historical lack of legal systems for producing relevant information plays an important role. So at the local level, there has been such strong resistance to state control of groundwater allocation that there has also been significant resistance to centralized collection of information about groundwater quantity. So there is no general requirement in the state that water users meter or measure the groundwater that they use. The state only established a law to provide for monitoring groundwater levels, which is what you need to reveal depletion, in 2009, after a very lengthy political struggle. But still today, even something as simple as records of where wells are fraught with problems because of the different ways that information is recorded by governments. As a result of that, there's really no easy way to get a complete picture of how water quality and water quantity have changed over time in a location. And that's crucial information to support any analysis of the human right to water, any analysis of environmental justice. I think this is a case of the principle of the streetlight effect, the anecdote that a man who's had a little too much to drink loses his wallet in the park and then searches for the wallet under the streetlight rather than in the park because that's where the light is. In other words, we try to understand and deal with problems with the information that's readily available. And in this case, information about groundwater depletion and its effect on vulnerable communities is not readily available, even though it's important. I think one of the reasons that it's not readily available is this historical struggle to retain local control of groundwater resources that has produced a severe reluctance to share information. Now, I say historical struggle because the 2014 Sigma legislation established a sort of truce between the state and local agencies, whereby the state is required to oversee local implementation of locally developed groundwater sustainability plans that are supposed to consider the interests of all users, including by establishing groundwater monitoring networks, which presumably should include vulnerable communities that depend on groundwater as drinking water. In carrying out its oversight function, the state will also be required to consider the human right to water, which does not apply to local agencies when they're formulating these plans, which is quite interesting. Whether that oversight function works to start to improve the situation should become clear in the coming months as implementation of the law proceeds. But interestingly, the State Department of Water Resources rejected an initial round of local groundwater sustainability plans as not sufficiently considering the interests of users. So the next few months will be interesting to see how the local agencies come back in response to the state stepping in like that. So I think in summary, when we're looking at Fresno, looking at issues at the intersection of groundwater sustainability and environmental justice, we can see that there are multiple layers of laws that make the statutory picture very complicated. These pieces of legislation conceptualize the problem very differently in terms of space and its human and its physical aspects. And there's a key gap connecting the threat of groundwater depletion to environmental justice. They also use really diverse ways of intervening in response to the problem, but there's a key gap in regulation to limit groundwater withdrawals. They've created a situation in which it's been difficult to gather information about the scale and the nature of the problem in different areas, to some extent because of the reluctance of local governments to give information to the state in fear of giving up power if they give up information. And this has made it difficult to identify communities that are most affected by cumulative burdens of environmental stress, including depletion, for the purposes of directing efforts at intervention and participation in laws. On the positive side, emerging state and local coordination under statutory mechanisms, even though it's very controversial, may help to improve the situation. I think stepping away from this case study, the issues that it highlights, I think, are of common interest in other very different cumulative environmental problems. I think it highlights challenges around the intertwined nature of inconsistently conceiving of communities of concern related to problems with producing information to address environmental justice concerns, and the challenges of just the information piece of the puzzle in multi-level settings where there's a real struggle for control. So with that, I will wind up and welcome discussion. Grazie per l'attenzione.
Thank you. Thank you, Rebecca, for this fascinating presentation, which gives allows us to have a grasp of the inherent complexity of the underlying issues. Now, according to the program, Federica Cittadino from Eurac Research will give her remarks. Federica Cittadino is a researcher, senior researcher at the Institute for Studies on Federalism and Regionalism at Eurac Research in Bolzano, Bozen, and was a leading force in organizing this seminar. So please, Federica, you have the floor.
So first of all, good morning, everybody, and I'd like to thank the STALS group as well for hosting this webinar, and of course to congratulate Rebecca on the research work she presented today. I think this is the first time she presents her unpublished manuscript, and for this manuscript in the form of an article, she was chosen as the Federal Scholar in Residence for 2020 of my institute. And she should have come to Bolzano to discuss her research, but of course the pandemic prevented her from doing this. So this webinar today is all the more important. I think that Rebecca raised a lot of important points today, and I would like to highlight some that I deem particularly innovative. And I will concentrate more on the conceptual implications of the case she presented, because I think this is interesting from a comparative perspective. First of all, it is very interesting and innovative that Rebecca borrows from the scientific literature the concept of cumulative environmental problems. As Rebecca demonstrated, this concept is useful to explain the complexity of both environmental problems and of the policy responses to address them. In general, this dialogue that Rebecca started is a sign that environmental scientists and environmental lawyers have a lot to say to each other, and that research in one area could inform research in the other. And this is also a call for a change of conceptual paradigms that is advocated by many scholars in different disciplines. Think, for example, of the acknowledgement that we have now moved from the Holocene to a new geological era called Anthropocene, which highlights the impacts of human action on the integrity and sustainability of the environment and of human life. And some legal scholars have advocated for a different legal paradigm called Law for the Anthropocene, and I refer here in particular to an article by Kim Blanchard and Coetzee of 2022. And according to this article, legal regulation and legal analysis should go beyond the borders of existing legal disciplines to embrace environmental problems with all possible tools, coming from different disciplines at different levels. And I think that Rebecca's research goes in this direction. I also appreciated a lot that Rebecca's research agenda goes beyond the classical debates concerning correct allocation of environmental powers, which is the most common topic discussed in federal studies. The main underlying question in this sense used to be on the basis of which criteria should environmental powers be allocated among different government levels. And of course, this question assumes that there exists a coherent and well identifiable rationale behind the division of environmental powers. Rebecca's focus on cumulative environmental effects instead brings to the fore the importance of assessing the effectiveness of environmental outcomes and of setting up coordinating institutional arrangements that may effectively address complex environmental problems. I think that her approach has the potential to expose the incoherence or inconsistency between declared rationales for dividing competences in a given way and the results that this division produces in practice on the effectiveness of environmental law. Another related point is what Rebecca calls casting the statutory net system to see which pieces of a legislation may apply to a given environmental problem. It's evident from the example made by Rebecca that not only purely environmental regulations matter, but also sectors that may have repercussions on the environment are particularly important to address cumulative environmental problems. And these other policy fields may be in the competence of different levels of government, which of course renders cooperation and coordination difficult, but all the more essential. For example, we cannot have a clear understanding about how climate change is addressed in any legal system if we only look at climate-specific legislation and strategies. Very important pieces of the puzzle are legislation on energy matters, but also in other sectors such as water protection and management, mobility, landscape, and territorial planning. Another important point I'd like to highlight is the hint Rebecca makes to the role of participation and involvement of citizens and groups in the conceptualization of environmental problems. So if an environmental problem is deemed to concern only the subnational level, then the groups that will be involved in the definition of the problem will be only those related to the concerned territory. And this, of course, has repercussions, as Rebecca illustrated, on the evaluation of whether or not resources that could be perceived as scarce at local, regional levels are not, for instance, at national level or vice versa. And therefore, choice about the relevant scale has consequences on the evaluation of foreseeable impacts and on the actors that are responsible for dealing with some environmental problems. The importance of information is another relevant point that has repercussions on which levels should be competent to regulate environmental problems. One of Rebecca's arguments is that the national level is the most fit to ensure both enough financial resources to collect relevant information over long periods of time and the standardization of methods for collecting data in order to make them comparable and then useful to inform policy making. The national level might also be best placed to address issues of environmental justice. And to my knowledge, Rebecca is one of the very few authors that makes a connection between multi-layered environmental governance and issues of disproportionate impacts of environmental problems on some parts of the society. The last point I would like to raise is that, as suggested by Rebecca, overlapping regulations by different government levels may be a positive factor. Because as recognized by extensive literature on environmental federalism, this may prevent agency capture and offer opportunities for experimentation and participation. This debate, in my view, partially overlaps with the research by Elinor Ostrom on polycentric governance and climate change, where she highlights that not only governments, but also other types of private actors, such as firms, but in her view, even families, groups, may adopt norms that are able to influence the governance of climate change, and that these jurisdictions overlap with governmental regulations. And this is good because it helps avoiding lack of regulation and legislative gaps. So with a view to recap, maybe in a too simplistic way, what Rebecca argued today, all levels of government have an important role to play, and that's why coordination is the key to effectively address cumulative environmental problems. So these were the points I wanted to highlight, but I'd like to ask Rebecca also some questions on the research she presented. Two more theoretical questions and one more linked to the case study of California and Fresno. So first, the problem of the scale of the environmental problem at stake is usually not discussed in explicit terms when it comes to analyzing the effectiveness of environmental protection. Effectiveness per se is usually at the margins of the scholarly debate on the multi-level governance of the environment. Maybe also because it's difficult to evaluate this aspect in purely legal terms. So the most commonly discussed problem is instead which level of government is responsible for dealing with some environmental problems, both in terms of adopting legislation and more executive acts. This problem usually triggers litigation before constitutional courts and is usually resolved by judicial decisions rather than being prevented through cooperation. So in this context, do you think that the conceptualization of environmental issues as cumulative environmental problems may help overcome this impasse? And second, the fact that we need to cast a broader statutory net to effectively address environmental problems was traditionally deemed to derive from the nature of environmental law as a transversal matter or value that touches upon different interests and policy sectors. in this sense, in which ways does the concept of cumulative environmental problems innovate from the previous picture? And finally, a question on the case study. Your conclusion that fragmentation of regulation is one of the biggest problems when it comes to protecting water resources in California is certainly true for other national and subnational cases. A good example is the case of Italy, which of course has implemented the EU Water Framework Directive, but due to the multiple regulations preceding the directive and the competence of some regions in subject matters such as water services, for instance, has a very complicated and little coordinated system of plans to monitor and enforce quality and quantity standards agreed upon in the directive. There are also different ways how to collect data and to evaluate them. So apparently there are similarities among these two cases. But to what extent, in your view, the lessons and best practices learned from the case of California may be transferred to other similar cases? And what are the main obstacles to this transfer? And I ask this also because I noted a very big difference between the two cases discussed today. So California and Italy, on the one hand, we maybe have a lack of involvement on the part of the state, whereas in Italy, we have maybe an over-involvement of all competent levels. So do you think that it's still possible to make a comparison, and in which ways? And I stop here. Thank you.
Well, thanks indeed, Federica. And just one technical issue. Rebecca, may I ask you to unshare your screen?
Of course. Oh, here we go.
Yeah, thank you. Now, we have some time for discussion, so I don't know if any of you in the audience is willing to ask questions. I see Gurkan Chapar, who is a PhD student at the Scuola. Any other? If you are willing to ask a question, please raise your hand, like Gurkan has just done. So please, Gurkan.
Thank you very much, first of all, this great presentation. It was really illuminating and very insightful. I would like to point a dimension which is generally discussed also regulation in international law generally. Sometimes fragmentation can be seen as an advantage, especially we have these kind of global public commons problems, because it is really hard to reach a one right answer, especially when you have very diverse problems, when you have different stakeholders. For example, there's a lot of literature written by Abbott and Keone in especially they also approach like polycentric approach, but they call it regime complexes, and they thought that sometimes regime complexes can be useful to find solutions to some specific problems, especially under conditions of uncertainty and knowledge gap. Especially justice is essentially a contested concept, and it is really hard to find a one solution. And under these situations, maybe this fragmented environment can help us to reach a beneficial outcome. And when we think about especially this frog analogy, maybe frog are the states that we are cumulatively nudging them to the outcome. They don't even recognize that they are losing. They are ending up in a situation that we really want to make them to reach. Do you have any idea or about this issue? This was my comment. Thank you very much once again.
Thank you.
And thank you to Federica also for your comments and your questions. I guess maybe if I take Gurkan's question first.
Sure.
The advantages of fragmentation. I don't doubt that there are advantages of fragmentation. The main purpose of the work that I'm doing is to help understand the ultimate results of fragmentation so that we can actually assess, is it advantageous? Are there gaps? Are there things that no one's paying attention to? Are there points of coordination where coordination's not happening and that leads to outcomes that are unintended? So I think that the problem of fragmentation is just that it's so hard to untangle. And so actually empirically determining, is this a good thing, is pretty difficult. And so my objective is to help make that process easier. And really that relates to one of Federica's points about the fact that legal scholarship doesn't often consider the effectiveness of environmental protection. And for that, you need to bring in non-legal disciplines. And I mean, I really embrace that, because I think my ability as a lawyer to understand the situation in California is just immeasurably increased by collaborating with an environmental engineer. And, you know, together we're able to collect and analyze physical data that reflects the effects of this incredibly complex regime of laws to sort of shed light on how the law is operating in practice. And so the intention with the book that I'm writing is really to attract both legal and non-legal audiences to the idea of analysis using the concept of cumulative effects, which is probably more familiar to scientists than it is to lawyers. But I think, you know, each has a lot to contribute to the other in understanding this just very complex situation that you can get when there is such an amount of fragmentation. But absolutely, I think there can be advantages, but our challenge is to figure out whether that's actually the case in a given situation. And if it's not, to try to remedy the inadequacies. A couple of other points just in response to Federica's questions. So the idea of casting a statutory net and the relationship between that and ideas that environmental law and policy touches on many sectors and many interests. You know, what's the difference between a cumulative effects concept and just acknowledging that these problems are big, they touch on many sectors and interests? So I originally became interested in the idea of cumulative effects specifically because I thought that the scientific literature had a lot to offer to law in terms of the difficulties that it wrestles with, which really go beyond recognizing that multiple sectors are involved. And so, you know, coming up with these 4 categories from very diverse interdisciplinary literatures is really what I'm most interested in, and applying that, not just recognizing that things are complicated, but also how can we use law to do something about it? You know, what are the problems that law can solve? What are the problems that law creates inadvertently when it's trying to solve problems? So for example, the legal process of generally assuming that small impacts don't need to be regulated. So de minimis effects are things that the law can ignore. Or grandfathering invested rights. You know, there's an established right to undertake an activity, but we're not going to regulate it because it's been going on for a long time. You know, these are examples of, if you apply a cumulative effects lens, it helps you isolate those instances where things aren't being caught in the net, where it really just, it goes beyond just recognizing that many sectors are involved. Another of Federica's questions was, you know, the interesting point that you make about the difference between the Californian experience and the Italian experience, and, you know, what can we learn from the Californian experience? You know, can we transfer lessons? I guess my first reaction as a comparative lawyer is that I'm suspicious of the temptation to say that a conclusion reached about one jurisdiction can apply in another, or at least not without a lot of analysis. But I guess my objectives in putting forward a framework for analysis of these kinds of problems is just to offer a way to systematically understand the same dimensions of difficult problems in different places. And so the proposed book's title refers to global best practices. And by that, I don't mean to suggest that individual legal mechanisms will be best practice necessarily in any particular jurisdictions, at least not if they're defined in a very granular way. But I do think it's possible to propose a series of analytical questions and offer a set of possible solutions that can help someone who is really steeped in the legal culture of a jurisdiction and the kinds of environmental problems that it experiences to think about what are likely to be effective solutions. So, they can take really diverse forms. So, for example, you know, in conceiving of a human population or an environmental value that you want to protect, one of the emerging things that many environmental lawyers are excited about is the idea of rights for nature. You know, that could be conceived of as the value that law is trying to encapsulate to defend it from cumulative effects, the rights for nature. But equally, you could define it as a species or a place. So I think it's more the approach that is transferable more than necessarily the specific legal mechanisms. I think I've covered those, and I'd welcome any other questions anyone has.
So thank you, Rebecca. Any other comments? Yeah, Federica.
Yeah, maybe I would be interested to hear more on my first question, which was whether or not this new conceptual understanding of environmental problems can help also solve the problem of lack of coordination between different government levels, and maybe to prevent litigation before constitutional and Supreme Courts. Thank you.
Yeah, so I will have a chapter of the book that deals with coordination and participation mechanisms that are used in different jurisdictions as a matter of practice to coordinate. And I think maybe that's an area that is most transferable because they're quite sort of mechanistic legal tools. So to give you an example from my home jurisdiction of Australia, where water is also a really important issue, the federal government intervened in 2007 in water, and it had never done that before in the entirety of Australia's history. And the idea of the Commonwealth legislature having the constitutional powers to do that was extremely controversial and based on the external affairs power. So Australia had signed international environmental agreements, and the thought was in signing these agreements, like the Ramsar Convention for the protection of wetlands, for example, well, that grounds the Commonwealth legislature's power to legislate in relation to water. So this was quite a new approach to the issue. The way that it has exercised that power is in part to essentially force coordination. So it has given powers to a federal agency, the Bureau of Meteorology, to require water information to be given to it by state and local agencies. So these are mandates. The water information has to be provided in a standardized format so that it can be easily aggregated across Australia to produce water accounts, which have turned out to be the foundation, or an important foundation for Australia's water markets. And so I guess that kind of legal mechanism, it's a standardized approach to sharing information, requiring coordination between different agencies. That kind of a tool, I think could be transferable. As to whether that kind of thing can avoid litigation, probably not in that specific example, and certainly that the legislation that I referred to in Australia is very controversial. It hasn't been the subject of constitutional litigation yet, which is maybe a little bit surprising. I'm sure it will come. But I guess more broadly, if coordination can prevent the accumulation of environmental problems to the point that they're so severe that people are driven to litigation, then that will be a success. But it will be a success that's empirically hard to determine because it's hard to determine the counterfactual, what would have happened in the absence of this. I think it's possible, and I think it's a good aspiration for a system to have.
Well, thank you. Any other feedback from the audience?
Just a very theoretical question. I mean, I really enjoyed the presentation offered by Rebecca, thanks indeed, and also the comments, of course, given by Federica. My question is very abstract. I noticed that your presentation and also in the title you refer to multi-level legal governance. So we have had a huge debate in Europe about the theoretical nature of this theory called the multi-level governance and also multi-level constitutionalism. And some of us, I mean, think that this is a very descriptive concept, while other authors suggest that multi-level governance and multi-level constitutionalism can also help in providing us with criteria to solve normative conflicts. What do you think about that? Is this relevant? Are you going in depth in this debate while carrying out your monograph, or just a curiosity? I don't know if this is relevant. Thanks indeed, Devek.
I think yes and no are my answers. So in relation specifically to the term multi-level governance, for the purposes of this presentation, I've used the term multi-layered laws because I'm really confining myself to talking about laws. But I do think that the literature on multi-level governance, insofar as it points to other actors that are not legislatures, for example, I think there's a lot to be learned there that's really interesting. So for example, I'm in the process of a related project looking at how multilateral financial institutions use their environmental policies as instruments to address cumulative environmental problems. You know, these are not laws. Maybe these conditions will find themselves into the conditions of contracts with institutions like the World Bank, for example, maybe not. But the point is they have norm creation power, I think. And so this is not a statement that I think multi-level governance arrangements are good as a normative proposition, but I think that there are interesting ways in which actors, legislatures outside of, you know, also actors outside of government can play a really interesting role in creating norms which serve objectives of environmental protection and addressing cumulative environmental change. On the question of, you know, do I think these multi-level arrangements are good? The point of public participation in this framework for thinking about things is an important one, and one on which many people know very much more about it than I do. It's really something that I'm just starting to look into. But I think to the extent that multi-level legal arrangements facilitate participation by different groups of people and can target different groups of people that may not otherwise be able to participate in decision-making if it were confined to a single level of government, then that has to be a good thing. And I would see that as one of the primary advantages and a normative benefit. But I defer to other people's greater expertise on that matter specifically.
Thank you. Yeah, this is a crucial point also from a comparative perspective. So the potential of the multi-level framework for unexplained, but also providing an operational framework, and of course this is quite crucial for us in Europe. I don't know, are there any other? Elisabeth Albert, please.
Yes, thank you, Rebecca, and yeah, good to see you all, and thank you, Rebecca, for this really brilliant presentation, and also Federica for the comments. I'm not an expert in environmental issues, But as you were referring to the fact of public participation at large with citizens, with stakeholders, whatever it is, we have in Europe this hype now. I mean, there's different countries that actually organize at national levels climate change citizen juries, or however you want to call them. And they're right ongoing now. And obviously, I would share the point that it is a good thing because it raises awareness, first of all. But what is the second thought of it is that in all this, allow me the term of participatory hype, let's say, I miss a bit the link to what I would call the public policy sphere, in the sense that very often, and this is an observation without having studied it very thoroughly, I see or I miss the fact that there is not a much of an attention to the feedback loops, in the sense that laws actually get evaluated, and the impacts get evaluated after, I don't know, 5 years, whatever it is, 3 years, whatever it is, depending on the scope of the laws, of the policies. And if they get evaluated, often then also it's completely, totally other stakeholders or persons or whoever is involved in it. And so I was wondering if I don't know, Australia, Victoria, I know myself, there is a lot of ongoing issues also when it comes to the right, let's say, to nature in a very broad sense, and to participation with the indigenous peoples. And Victoria is actually a prime example in that within Australia. So what do you think about feedback loops and about the public policy perspective to it, if you know? I know it's a very broad comment, but and difficult one, but I think there is a missing interdisciplinary link. I don't know how to call it. Thank you very much.
So I take it, thank you very much for the question. I think, as I understand it, when you're talking about feedback loops, it kind of relates also to this point about almost adaptive management as such, that you can't just deal with something once and then it's dealt with. You know, people participate once, that doesn't answer the problem for all time. Once you understand how a law is being implemented, you need to feed that back to the people, have more participation in an iterative process. If I've understood that rightly, I'm interested in the idea of Drysek's idea of deliberative democracy, where there is some kind of ongoing effort to institutionalize deliberative processes in institutions as a regular thing, or to include legal structures that ensure that there is that iteration in the process. Because I agree with you, you can't just do something once and then think that you've done it and continue. And I mean, in the field that I'm most familiar with, in water law, everything is very much based around statutory plans, and these plans have to be revised every several years, and there are public participation processes to do that. I'm not sure that we do that all that well in Australia. I think it may maybe be a result of the cultural preference for direct democracy that I see in California, but the degree to which they expect and get meaningful, repeated public participation in their water laws stuns me, frankly. And, you know, there's participation in every part of the decision-making process, from what should the boundaries of this groundwater basin be, for example. In Australia, that's a science question. The public doesn't get involved in a determination like that, but it clearly has implications for, you know, who has territory, who has decision-making power in relation to a particular area. You know, in California, they start there and they go sort of all the way through to the minutiae of thinking about allocation. So I think there are some things that Victoria does well. I think public participation is not necessarily one of them. But yeah, I absolutely agree with you that it's an important issue. How do you institutionalize this iterative process? Yeah, thank you.
Thank you. So I think we have had a good debate. I don't know, Federica, would you like to add anything?
I think that at this stage I'm satisfied with what Rebecca said and added to her presentation. I found particularly interesting also the last comment on participation and the ways in which this has to be institutionalized and yeah, made an integral part of decision making. And perhaps the a more general comment would be that so I try to kind of do this parallel between environmental federalism and what Rebecca is doing in her research. But I come to realize now that there's a big difference because somehow Rebecca is looking at the more operative part of the laws and application of concrete environmental laws, while theoretical debates in the field of environmental federalism have concentrated more on the constitutional part of the division of powers. And these are two different aspects, although interrelated. And I think this is the way Rebecca can innovate in the field. So yeah, I found that the presentation very insightful, and I look forward to reading the book of Rebecca.
Well, I think we all agree on this. We are looking forward to reading this output of Rebecca's research. So thanks indeed to all of you for attending this webinar this morning. And of course, many thanks to our discussant and to our main speaker, Rebecca Nelson. We are very happy of this cooperation with Eurac Research, who allows us to hear fresh voices, fresh contributions to the transnational academic debate on such topical issues of environmental law. And well, let's keep in touch and have a nice day. Again, many thanks, and see you at the next STALS webinar.
Thank you.
Bye.